a traffic stop was initiated, and the officer observed the driver leaning.
Right off the bat, this is what officers call a furtive movement. Basically, any quick motion that might suggest hiding contraband. But here's the question for you. Do you think leaning over automatically means guilt, or could it just be someone grabbing their wallet? Comment below. This is where probable cause gets messy.
Over the console, trying to conceal something next to the console in the front passenger seat. The driver and the passenger did not see the officer as he was standing near the driver window, where the officer observed the driver have his hand between the front seat and the center console. The officer ordered the occupants out of the vehicle and observed a plastic bag containing a green leafy substance with an odor of marijuana as the front passenger exited. And the front passenger immediately took off running, and the defendant, the driver of the vehicle, stated he only knew the passenger to be named Junior. The weight of the marijuana was 0.3915 ounces.
Judge, looking at the totality of the circumstances, the state has not been able to allege enough probable cause that my client knew or intended that there was marijuana in his possession. I understand that the allegations say that there was some type of furtive movement, but my client yielded to law enforcement show of authority, and then gave law enforcement his identification. The passenger ends up leaving law enforcement. He stays there. And again, there's not enough to establish that he knew or intended that there was weed in his car. The allegations also don't, pinpoint where the marijuana actually was. So this was this was unbeknownst to my client, Judge.
So he officer comes up to the car, and he sees him trying to conceal.
Yes.
Right?
I don't think that, I believe the allegations say that that's what the officer maybe seems to believe, but after further review, there's nothing that says that's definitive or that's even probable cause. For all we know, he was rummaging around to give him his ID, which he did. That's why he got picked up.
No, but he says he's got a plastic bag, and he's trying to put a plastic bag behind the console.
Yes, Your Honor, they found his hand between the front seat and the center console. They observed his hand in between the console.
Was it a plastic bag too?
It says that they observed a plastic bag containing the green leafy substance. Yes, Your Honor. And that was after the passenger exited. So when they walked up, they saw him with his hand in between the console and the front seat, where they observed him trying to conceal something.
So, Judge, in the DIMS, it says, quote, as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance. The way I'm reading that, Judge, is that's more attributable to the passenger and the alleged marijuana that was near his person than it was my client. Again, the rummaging around, Judge, I don't think there's enough of a nexus to establish that. My client yielded to law enforcement show of authority. He gave law enforcement his ID. While he's standing there submitting to law enforcement show of authority, the guy with his hands up with the marijuana that's around him leaves. So if anything, this should be attributable to the passenger.
Saying that the weed is the passenger's client, not your client. That's what you're saying.
Yes, and based on the allegations, Judge, there's not enough probable cause that attributes my client knew or intended that marijuana was in his possession, when everything just as much points to someone who ran away from the cops.
Hit the gyms again, and then who is the one who's allegedly hiding things?
It's the driver, Your Honor, which is the defendant.
Right.
The officer said the officer observed the driver have his hand between the front seat and the center console, and previously...
Okay, wait. So between the front seat
in the center console, and the officer said, I observed the driver leaning over the console trying to conceal something next to the console and front seat passenger, and that's where he observed his hand in the front seat, between the front seat passenger and the console.
This is the moment where the entire case pivots. The judge is laser focused on one thing. Who was actually hiding the bag? The driver? The passenger? Both? This confusion matters because possession charges require affirmative links. If the officer can't clearly say where the weed was or who had control, the whole case starts falling apart, and we can already see the judge getting frustrated.
So the officer observed him trying to conceal something, and all the DIM says in regard to the passenger and the marijuana is that as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance smelling of marijuana. It doesn't say anything in regard to it being solely in the passenger's area, because it said previously he was trying to conceal something.
Again, my apologies, Counsel. Judge, if I may.
he's actively trying to conceal a plastic bag?
Your Honor, so with this situation, when we were briefly speaking, allegedly
give you a
this
second.
driver
Yes.
and passenger don't know each other, but then in this situation, should this person, the defendant, be pulled over for speeding, one would think he'd keep his hands 10 and 2 and not be trying to conceal something. So that's where we're at. And if you didn't know that didn't know the passenger, didn't know that they had the marijuana, didn't know anything about the marijuana, why are you concealing? Why aren't you keeping your hands at 10 and 2?
Judge, anytime somebody's driving, again, I think there's a reasonable inference that goes just as much to my client was trying to go through his belongings, give law enforcement the correct identification so that he could submit to law enforcement show of authority. Again, just because it says concealed doesn't mean that there's enough allegations that actually substantiate that anything was concealed. If anything,
No, but is that enough for him to continue and to investigate further? Right. His allegation is, I come up to the car and I actively see someone trying to conceal something. So at that point, I'm going to investigate further.
my issue is not law enforcement had the right to further investigate the case. We understand that my client was speeding, Judge. My issue, though, is that they're saying that the front seat passenger is getting out of the vehicle and then he sees weed as the front seat passenger gets out. My client is already
So who do they both have weed? Is that what happened here? Do they both end up with?
My understanding, Judge, is that there's enough probable cause that actually goes toward the passenger being in possession of the
Did they find weed where he was trying to conceal whatever he was trying to allegedly conceal?
The allegations are not clear about that, Judge, which is why.
Admittedly, they are not clear about that because all it says is that as the front seat passenger exited, they observed the plastic bags. But previously, they did say.
Where?
It does not say, Your Honor.
That sucks. Then write a better report.
It does, but they did say
You know?
that concealing something.
I need to know, where is the weed in the front seat passenger?
There are enough affirmative links still because he's the operator of the vehicle and is within his wingspan, and they saw the previous furtive movements being made to draw the inference of knowledge. So there's enough affirmative links between him and the contraband for a probable cause.
I don't work on hunches.
It's not a hunch.
Hunches here. I mean, it's not that hard to write in the report. Well, I saw weed where I found his furtive movements. You know?
Yes, Your Honor. They didn't clarify that, but they did.
Then too bad, so sad. Sorry.
I will say, Your Honor, this did just happen 2 days ago. If we could wait to get the offense report, maybe he articulated it
No,
more.
I mean, I he's in custody. I don't want to wait 2 days because he's in custody. If he was on bond, man, perhaps, but he's in custody. He's in jail, just sitting there. You know, I'm with you. Okay.
Thank you, Judge Fletcher.
We're gonna.
Yeah. I mean, Alex, I'm not asking for much, just a little clarity. That's it. You know, and I bet you now, hopefully, never make that mistake again. Come up. Who are you? Come on up. You can come too. Why on two different sides? You embarrassed to be with your mom? Okay.
I separate
Got it.
family and spectators.
Okay. Good morning, Mr. Hardy. Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and one blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, one red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana.
Oh, but because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the
Yeah,
issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
I didn't see that, Your Honor, give me a second. At 4 in the morning.
And Your Honor, I
Huge moment. The judge officially throws out probable cause. This case is a perfect example of why details matter. Unclear reports, vague observations, and questionable traffic stops can completely collapse in court. What do you think? Was this a justified stop, or did the officer stretch the rules? Drop your take below. This ending is going to spark debate.
In the morning.
4:30 a.m.
And he can delineate at 4 in the morning that parking 18 inches from a curb.
And I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
It's at 4 in the morning, you can tell.
Your Honor, the officer was,
Yeah,
yes.
I don't think so. All right, I'm going to find no probable cause.
Yes,
All right.
Judge.
Guys, be careful, right? You know, they're always out there. Just be careful. Do something with your life. Knowledge is power. Get into school, get an education, do something with your life.